Yes. All right, the court is calling 2025 CR 004887, State versus Juan Alberto Martinez. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Robert Featherston representing Mr. Martinez.
And you are Mr. Martinez? All right, your attorney has filed a motion for bond reduction. State, have you had a chance to review the motion?
Yes, Your Honor.
And do you waive notice?
Yes, Your Honor.
All right. So according to this, your client is charged with manufacturing, delivery, controlled substance penalty group 1. Let me see.
Hold on. Over 400 grams? That's not simple possession. That's trafficking level weight. We're talking serious prison exposure here. And yet the bond is sitting at $25,000. Now the defense isn't just asking for a reduction. They want a PR bond. That means walking out without posting cash. That's a bold swing this early. Let's see if the judge bites.
Is it over 400 grams?
That is correct, Your Honor.
Over 400 grams. The bond is currently set at $25,000, according to your motion, and you're asking for the bond to be reduced?
That's correct, Your Honor.
All right. Do you have any witnesses?
No witnesses other than Mr. Martinez.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Juan Alberto Martinez.
All right. Counsel, you may proceed.
Thank you, Your Honor. Mr. Martinez, you have a great concern about a family member. Who is that?
My mother was just diagnosed with cancer a week ago. And Mr. President has been doing a lot for me, but my case has been turned over from DA to DA to DA. I'm innocent of this charge, but I'm pleading to the court in any way that you all can help me. I mean, I'm willing to do anything you would say, but I am my mom's oldest son. She doesn't deserve to die alone. But I am innocent of this charge, but I would plead no contest to the court. Whatever, if somehow I can get probation, whatever stipulation you can put, whatever.
All
I
right.
would
So
have-
this is
oh.
not,
No, but I'm
The
just
time
stating
for
that I have,
equalization.
that's the problem with my mother. She got cancer. That's what he's stating, my mom.
Your Honor, if it pleases the court, he's under a great deal of stress because of this issue with his mom. He originally started with the PR bond, and then his bonding agency asked for a bond increase as a result of some issues associated with his bond. I think the state will probably go into more detail in that. But we're respectfully requesting that the court reconsider a PR bond for him. There is no violence involved in this particular case. And he would like to be able to provide some assistance to his mom. I'll pass it.
all right, you may proceed.
I don't really have any questions in this particular case.
All right. So, does he have any funds?
Judge, I'm appointed to his case. He is indigent. And I do not think that he has any funds that he can draw on, considering what has now happened to his mom, which was his sole source of income prior. I don't think that she's going to be able to come up with any money in order to be able to get him out on a bond. He has no bank accounts, no personal property, no real property to rely upon in order to get anything other than the bond.
All right.
Here comes emotional appeal. Sick mother, sole provider, no assets, no money. But in court, emotion alone doesn't lower bond. The judge has to weigh flight risk and public safety. And notice this move. She doesn't say yes, she doesn't say no. She orders an evaluation. That's judicial balance. Compassion, but with caution. Fair call? Or should she have ruled on the spot?
So what I'm going to do then, because you're saying there's no amount of bond he can make, he needs a PR bond. Is that correct?
Yes, sir.
All right. So in this case, Ms. Ferguson, have him evaluated for a PR bond. And once the evaluation is complete, we'll have him brought back. It shouldn't take that long.
Your Honor, you were most kind, and I thank the court.
All right. So Norm, I want him evaluated for a PR bond. And then we'll place him back on the docket as soon as that completed. It should be done by next week, hopefully.
Not a
And then-
problem, Judge. I'm here every day.
All right, thank you.
Here.
Hey, Pops. Hey, hold on for 1 second.
Thank you.
But the one time I did roll my R, everything just went haywire. So I don't think the universe was expecting it. All right. So today is plea deadline date.
Yes, Your Honor. So we were recently hired on this case,
Mhm.
just a couple days ago. We still need to go through the discovery, and Ms. Laraga has informed me that she has previous experience at the mental health court. We need to explore that also, if we could. So if we could get an extension on this plea deadline, we'd appreciate that.
All right, who's the prosecutor on this case? Shakira Laraga? Right, did you confer with the state?
Yes, just briefly, Your Honor, just to let them know that we've been was recently retained on the case. So we need to evaluate the discovery.
All right, so today is plea deadline date for them. She's previously been in a treatment court in the county court. And the last time we were here with this, there was supposed to be a consideration of the fact that she was in a treatment court.
We were just hired a couple days ago. I didn't realize that's been previously brought up to the state.
So, Ms. Ferguson, set this for the second week in September, and that will be your plea deadline date.
Thank you, Your Honor.
What date? All right, September 8th. Thank you for addressing appropriately for court. All right, just have a seat and your attorney will bring your reset form.
Thank you, Your Honor.
You too, have a great day.
He formally rejects the offer.
And there it is. I feel coerced. That word hits hard in the courtroom. But watch the shift. The judge doesn't escalate. She educates. What follows is basically plea bargaining 101. If you've ever wondered how pressure, offers, and trial rights actually work, pay attention. This is real-world criminal procedure in action.
All right, so do you want a jury trial or a bench trial?
Ma'am, look, I feel like I'm being coerced into signing for something that
No, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once a grand jury indicts a case, which doesn't mean anything, it doesn't mean you're guilty. It's just telling what you're charged with. It gets assigned to a court. And then you get assigned an attorney, and you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, the state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. And then that's called a counter offer. Your attorney is ethically required to give that counter offer to the state. And the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So railroading, whatever you feel railroading is, if you feel railroading is the state is not making an offer that you find acceptable, then to you, that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial, a lot of people think that they get to determine, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I or the judge who's sitting here, we're here, whatever evidence is presented, and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box, 12 random people, right? They'll sit in the box. The state will present their evidence to that jury or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. Hypothetically and normally, this is what usually happens. The state has to prove that it happened in Bexar County, because if it didn't happen in Bexar County, then I don't have any jurisdiction. They usually have to prove an on or about date, and they do on or about dates, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say certain items of value were taken from me without my consent, which means I didn't give this person permission to take my things. This person took my things. And usually a robbery involves some type of physical force. You know, if somebody is walking around with a purse and you snatch their purse, maybe that's a theft of a person, but it could potentially also be a robbery. It just depends on the way it's charged. So that's what the state has approved if it's a robbery case. If it were a drug case, they would have to bring in a chemist to say, yes, these are drugs and these are illegal substances. And then somebody would have to prove that you're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial date. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought to you. So do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
A reason why I don't want to take what the state is offering me because it's I don't think prison and
Here's the
I
thing.
would recommend.
Let me just tell you, whatever the state is offering you, I'm not involved in what their offer is. But what I can tell you is, if you look over in that box,
That statement? Quiet but powerful. Nobody thinks prison is for them. Judges hear that every single day. Here's the legal reality. Thinking an offer is unfair doesn't equal coercion. The prosecution makes an offer. You take it negotiated or risk trial. That's the system. So now the question becomes, is he making a calculated move or a dangerous gamble?
I guarantee you nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. They'd be like, prison's not the place for me. Nobody thinks prison is the place for them. You may once every 200 cases have somebody who'll say, yeah, I deserve to go to prison for this. But normally people don't say that. So I don't need to hear about your negotiations with the state, because ethically, I'm not supposed to hear about that.
they're not even trying to hear me. He's not even trying to hear me. That's why I wanted to dismiss.
Okay, so state, who's the state on this case with Jacob?
I confer with Jason.
All right, Jason. All right, Mr. Andrade is informing the court that he wants a dismissal. Are you going to dismiss this case?
No, I'm not saying to dismiss the case.
All right, so he wants something other than what you're offering him. Are you intending to offer something other than what you've already offered?
It's just the case that we discussed.
Okay, yes, so thanks. But after conferring, no, Judge, that's the offer.
All right, so he's saying he's not going to change the offer that he has made.
In fact, Judge, just sorry to interrupt you.
No,
Judge.
no.
That would be today only offer since
All
would
right,
be
And
changing.
that's how I feel in track. Like,
all right.
I feel like I got an ultimatum. I feel like if I hired another lawyer, I have a better chance to, get a drug program, because the whole reason why I'm not running from what I did. I
wouldn't seek further, but don't admit any guilt. Just please don't say something. Your Honor, we were here on a prior setting earlier this week. He had some time to think about this.
Mhm.
I know Jason is leaving.
So today is the day you make your decision. If you don't want to accept the offer, then it's going to jury trial or either bench trial. So you can sit in the box And then I'll bring you back up at 10:30. And you need to let the court know whether you're accepting, if you've reached an agreement or whether you're going to jury trial. Those are your options.
Okay.
All right, thank you.
Discovery wise, we're fine, Judge. My client wants to to replace me with different counsel.
Mhm.
He's not cooperative with me. He has suggestions which I disagree with. And he's got a pro se motion in his hand, wanting to replace me as counsel.
All right, so are you going to hire your own attorney?
I was seeing it up in with somebody different from me.
No, this is your attorney. And so here's the thing. You can either talk to your attorney or not talk to your attorney.
It's not that me not wanting to talk to my attorney. He's been given certain types of evidence that he's not willing to share with the DA, messages, things that have happened to my wife.
Let me ask you something. Here's the thing. Maybe if he is not sharing something with the prosecutor, maybe it may be because it's in your best interest that it not be shared. So I don't know anyone. This has to be the only profession where people get an attorney and they think that we have no knowledge, that all we're doing is talking. But there's a lot of knowledge behind that. And everybody thinks that they can be an attorney without having gone to law school. I have yet to meet anyone who goes to see a doctor, and if they're ill, they go to the doctor and then they get their second opinion or whatever. And then they say, you know what, doctor, I know better than you. So this is your attorney. If you want another attorney, you're more than welcome to have one, but you will have to hire that attorney. Do you understand?
Yeah.
All right. So we're going to set this for a plea deadline date. Norma, set this for a plea deadline date, the third week in September, please.
If I can speak freely on,
I don't know if your attorney wants you to speak freely, but I was willing to listen.
Judge.
there's a person that this happened to on this case has made false police reports and everything else.
Mhm.
He's not willing to share any of this with the DA.
He's saying that somebody made a false police report on this.
Not to my knowledge, wrong. January 25th. You haven't showed him anything, right? There was refusing to show
All
him
right.
anything.
So we're going to come back on September 18th. I'll need an acknowledgement of discovery completed. All right, so we're going to bring you back on September 18th. September 18th will be your plea deadline date. And then next date will be a jury trial date.
That'll work, Judge.
All right, thank you.
Thank you.
Yes.
Michael, 3, 5, 8,
Okay. All right, court is going on the record. Court is calling 2025 CR 1023 State versus Mark Lunsford. Can I have parties announced?
Austin Stout for the state.
Sam Cogdill and Sam Log from the Schmucks.
And are you Mr. Lunsford?
Yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Lunsford, did you review the application for deferred adjudication or community supervision with your attorneys?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, sir.
Counsels, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, except the state does have a motion to waive counts 2 through 55 and proceed only on count 1.
Any objections?
No, ma'am.
Mr. Lunsford, did you review the document entitled, just one moment. Did you review the document entitled Court Admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with money laundering? Everyone.
And now we pivot. Money laundering over $300,000. That's first-degree felony territory. 5 years to life. This isn't minor league anymore. Listen to how carefully the judge walks through every right being waived. That's not routine. That's protection of the record. Because once this plea locks in, appeals get very narrow. This is how a textbook plea hearing is supposed to look.
Please whisper. Did you understand you're charged with the offense of money laundering less than $300,000 as a first-degree felony? Range of punishment is anywhere from 5 to 99 years in life and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
We discussed the defenses with him, Your Honor.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Lunsford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand if you're not a United States citizen, by entering into this plea bargain agreement, you can be deported, not allowed naturalization or re-entry into the United States?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, sir.
According to the plea bargain agreement, the state is proceeding on count 1. They're asking that your punishment be assessed at 10 years in the prison. There's a $10,000 fine. State is opposed to your application for deferred adjudication. There's to be restitution in the amount of $297,276.34. And you will not accept or maintain employment in any position involving the handling of financial transactions. Counsel, could you all check the box here and
Yes, sir.
initial? Did you understand that to be the plea?
Sure.
Defense, is that the plea?
With the caveat that the state was going to recommend probation. Thank you.
No, they recommend probation, but they're opposed to the deferred.
Yeah, ma'am, you just.
Sorry.
You said they're opposed to defer.
All right. So did you understand that to be the plea?
Yes, sir.
Do you understand that the state is opposed to your application for deferred, but they are recommending community supervision?
Yes, sir.
So do you understand if the court does not grant your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement? Do you understand?
Yes, sir.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be 200 hours of community service restitution, a cap of 60 days in the Bexar County Jail, no contact with the complainants listed, and felony anti-theft course in MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to count 1, how do you plead? Guilty, not guilty, or no contest? I'm sorry,
No contest.
state any evidence?
The state is offering State's Exhibit 1 and all attachments. And Your Honor,
Did you catch that correction? Over versus less than $300,000. One phrase changes the entire punishment range. That's how precise criminal law is. Small wording, massive consequence. And that's exactly why judges slow everything down on the record. Once a plea is entered, there's almost no rewind button.
I just want to clarify for the record that count 1 is first degree felony, but it is for money laundering over $300,000, not less than.
All right, thank you. I think the sign is incorrect. You know, when they do the sign, the less than sign and the more than signs. All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Sure.
Did you understand it and sign it in all the appropriate places?
Yes.
And counsel, I'm assuming you have no objections to the stipulations being entered?
We do not, Your Honor.
All right. Again, that you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
You stand there, speak clearly. The court clerk here.
Judge, President.
Yes, are you all, this states he has a motion to revoke?
Yes, Judge, this is our very first appearance on it.
Could I see the motion to revoke, please? Michael, I'm sorry, it's Patrick Nyong'o.
That's support me again? Nyong'o. It's our first appearance, Judge. We're close to resolving the case. I need to look into one thing, but next, we're asking for a reset, and at that time, we'll be able to resolve the case, I believe.
All right, Ms. Ferguson, can you set this for the second week? Second week for a MTR? Second week of September.
What town? Yes, can we do Wednesday the 10th?
Sure.
All right, so you'll be back on September 10th. All right, thank you.
Thank you, Judge.
You're welcome.
Oh, Judge, additionally, on a different case, we have this one.
And is there someone waiting for an officer? Van Bach?
One of the witnesses, Ms. Sawyer, had subpoenaed and said she needed. Oh, who else?
All right, thank you. All right, which
Page 5.
okay.
Patrick.
All right, Jacob Andrade?
Yes, Your Honor.
Yes.
Mr. Andrade has had time to think for you. And he reasserting his position that the dismissal is not for the case, the dismissal is for counsel to be dismissed.
Okay.
He wants a new attorney, and we would ask just have this go to a jury docket.
All right, Ms. Ferguson, I need a jury trial date. How long do you expect this trial to last, counsel?
Check to say it's a $10.
Oh, that one.
3 days, Judge. I mean,
All right, Norma, 3 days? And it's criminal trial division. And counsel, if you make sure I have an acknowledgement of discovery, I think I may have one, but just double check.
That was tendered on Tuesday.
Okay.
I signed it.
All right, October 28th. All right, thank you.
One courtroom, multiple high-stakes decisions, a bond battle, a plea standoff, and a 6-figure financial felony wrapped in procedure. Different charges, same judicial control. So what stood out most to you? The bond push, the coercion debate, or the money laundering breakdown? Let me know below.